Hi everyone, today I am going to discuss the Indian Forest Act 1927. This act is important for Himachal Pradesh Judiciary examination. The preliminary examination of this state judicial services is on 8th of July, and this act is important since around 5 to 7 questions are being asked regularly from this act. Starting with the preamble, this act consolidates the law relating to forest, transit of forest produce, duty leviable on timber and other forest produce. So these 3 points are important because usually the question is in the form like what does the preamble does not consolidate. So what we have to focus on, what it does not consolidate. For this we have to keep in mind it consolidates law relating to forest, transit of forest produce and duty leviable on timber and other forest produce. This act comprises of 13 chapters which continues from section 1 to 85A. The last section of this act has been repealed. Moving on to another slide. Chapter 1. Chapter 1, it deals with preliminary. I'm extremely sorry for this spelling mistake. Starting with section 2. There are certain questions which are specifically being asked from this section, which basically involves like cattle, what it does not include, river, what it does not include. So what you have to keep in mind while studying this act is what it not includes. And these questions, see, as you can see, questions from this section has been asked in 2018, 2013 and in 2011. So this forms an important area from which questions are being framed. Subsection 1 deals with cattle. There are lists of animals which are included in cattle. What is not included, and unexpectedly it is cows. Then comes subsection 4, forest produce. Subsection 5, river. What it does not include is ponds. Subsection 6, timber, and subsection 7, trees. These two things, they have been specifically being asked, that what is not included, are cows form part of cattle or not. So while revising, while the complete and the final revision, keep this in mind that you have to remember what is not included. Moving on to another slide. Chapter 2, it comprises of reserved forest. There are certain sections in chapter 2. It comprises from section 3 to 27. I'm going to discuss only the important sections from which questions have been framed. Subsection 3, power to reserve forest. Who can reserve forest? State government. This is important. What kind of property of the government, or what can be declared as reserved forest? Any forest land or wasteland which is property of the government. Then section 4, notification by state government. Notification regarding that it has declared a certain area into a reserved forest, it shall specify the limits. What is important here is that it shall also appoint a forest settlement officer who shall not hold any other forest office. At max, how many officers can be appointed is, it has been specified, only 3, out of whom 1 holding forest office perform duties of forest settlement officer. Section 9, extension of rights. Section 10, see, these are only important sections and you have to keep in mind like what the section number deals with, what subject matter, or what is the marginal head note of this section. Section 9 deals with extension of rights. Section 10 deals with treatment of claims regarding practice of shifting cultivation. Section 11, power to acquire land over which right is claimed. Now why I have written all these sections 12, 15, 16 is that appeals from the orders which have been passed under these sections, they have to be made within 3 months. This is important. And to whom? To officer of revenue department whose rank is not lower than that of a collector. So these things, these are the areas from where questions are being framed. Section 22, power to revise arrangements made under 15 or 18 section, and state government may revise such arrangements within 5 years. Then section 23, no right to be acquired over reserved forest except as herein provided. Only rights which have been granted under succession or under any contract with the government which is made in writing. Only those rights shall be recognized in the reserved forest, otherwise no other rights shall be recognized. Moving on to another slide, which comprises of section 24, 25 and 26. 24, rights not to be alienated without sanction, and sanction of whom? State government, since it is only declaring what is the reserve forest, so sanction shall be of state government. Section 25, power to stop waste and water courses in reserved forest. Forest officer shall has this power with previous sanction of the state government. Section 26 is very important, very important, because all these acts which are prohibited in the reserved forest, and questions are being asked continuously, repetitively from this section. So you have to keep this list in mind about what are those acts which are prohibited in such forest, in reserved forest. First is, it prohibits any fresh clearing. It prohibits setting of fire, or kindles, keeps or carries any fire. So basically prohibits any person from doing anything which is related to fire. We will just mark the keywords, and this is how you are going to remember the list. First is, and no fresh clearing shall be made. Second is related to fire. Third is related to cattle, trespasses or pastures cattle on the land of reserved forest. Causes any damage by negligence in felling any tree or cutting or dragging tree. So you cannot cut or drag any tree from the reserve forest without prior sanction or permission of the government. Then fells, girdles, lops or burns trees or strips of bark or leaves or damages the same. Quarries, stones, burns lime or charcoal. Now see, these were related to fire, this was related to fresh clearing, these are related to tree कटिंग नहीं होगा, उनका किसी और पार्ट को, लीव को, उनकी बाक को, किसी भी ऐसे पार्ट को जो ट्री का एक इंपॉर्टेंट ऑर्गन फॉर्म करता है, आप you cannot play with it, you cannot damage it. Then is related with lime, stone and charcoal. So no mining activities. It clears or breaks up any land for cultivation, you cannot clear up any land. No deforestation activities. Hunts, shoots, fishes, poisons, waters or set traps in contravention of state government notification or sanction. So you cannot continue with any of such acts, and these list of acts are important. If any contravention takes place, it is punishable with imprisonment for a term which may extend to 6 months, or fine which may extend to ₹500, or both, in addition to any compensation which can be imposed upon the wrongdoer. Section 27, power to declare forest no longer reserved. जब डिक्लेरेशन स्टेट गवर्नमेंट ने किया था, तो इस बात का भी डिक्लेरेशन कि वो अब रिजर्व फॉरेस्ट नहीं है, वो भी अब स्टेट गवर्नमेंट ही करेंगे. Then comes chapter 3 of village forests. Formation of village forest. Who is responsible for its formation? State government may assign any rights of the government to any village community, and whenever such rights are bestowed upon any village community, that land shall be declared as village forest. All such forests which have been given or assigned to the village community, they shall be known as village forests. Chapter 4 of protected forest. Now this chapter number and this what it deals with is important. It has been asked previously in 2016. So it comprises of section 29 to 34. We are going to discuss only these three sections. Section 29, protected forest. State government can declare any forest or wasteland as protected forest, provided it has not been declared as a reserved forest. So a particular forest cannot be a protected forest and a reserved forest both at the same time. Section 30, power to issue notification reserving trees, etc. Such notification shall continue for 30 years. Section 31, publication of translation of such notification in neighborhood, it shall be done by the collector. So basically declaration is being made by the state government, and publication of such declaration is made by the collector. Moving on to the next chapter. Chapter 5 of control over forest and land not being property of government. Chapter number, what it consists of, what it comprises of, important, 2016. Section 35, protection of forest for special purposes. 2007 this question was asked that who has this right. So state government has right to regulate or prohibit any activity in forest land or wasteland. Activities comprising of cultivation, pasturing of cattle, clearing of vegetation. Chapter 6, it comprises of sections 39 and 40. Section 39 important hai. Chapter 6 deals with of duty on timber and other forest produce. Section 39, power to impose duty on timber and other forest produce. As you can see, around 4 to 5 times this question has been asked from this section. Central government has the right to levy a duty. Very important, because usually this act is implemented or governed by the areas, or the areas are specified by the state government, but here duty is imposed by the levied by the central government. And on what timber and what forest produce? On the territories to which this act extend, plus from places where it has been, from any place within the territory, where from any place where it has been produced within the territory of India. Moving on to the next chapter, chapter 7, it comprises of section 41 to 44. 41 here is important. Chapter 7, of control of timber and other forest produce in transit. So power to make rules regarding regulation of forest produce during transit is vested in the state government. See, here you have to remember which power has been vested in which body. Usually the power has been vested in the state government for declaration of reserve forest, for declaration of village forest, for declaration of even protected areas. Here also control of timber and forest produce while transit, it is under the state government. Only one place where we have seen a different body, that is regarding levying of duty, and that is central government. ठीक? Chapter 8, of collection of drift and stranded timber. It comprises of sections 45 to 51. 45, certain kinds of timber to be deemed property of government until title thereto provided and may be collected accordingly. So what you have to keep in mind for this is that all the property is basically, the general rule is that all the reserved forest and the property comprised within it is of the state government, and this question has been asked in 2019. Moving on, section 46, notice to claimants of drift timber. At least 2 months notice time period must be given from date of notice. Section 47, procedure of claim preferred to such timber. Forest officer may either reject or deliver the timber to the claimant. Any person whose claim has been rejected may within 3 months institute a suit, and no timber subject to process of any such court shall be delivered to any other person. It shall be within the power, or within the, it shall be in protection of the court of the government. Chapter 9, penalties and procedure. This chapter is very important. It comprises of section 52 to 69. There are certain important sections from which questions have been regularly being asked. Like section 52, seizure of property liable to confiscation, 2016 and 2012. So here what we have to remember is what is the punishment which has been provided in case of any such offences has been committed. Section 52, seizure of property liable to confiscation. Offence committed in respect of forest produce. All tools which are basically used in committing any such forest offence shall be seized by the forest officer or the police officer. Section 53, power to release property seized under section 52. So this property can be released only by a forest officer whose rank is not inferior to that of a ranger. Section 55, forest produce, tools, etc. when liable to confiscation. Section 56, disposal on conclusion of trial for forest produce of forest in respect of which it was committed. Section 57, procedure when offender not known or cannot be found. Section 59, appeal from orders under section 55, 56 and 57. Why I was discussing these sections, or why these sections have been mentioned over here? Reason is section 59. Appeal from these from orders which have been given under these sections, it is to be made within 1 month from the date of the order. Section 60. See, section 52, very important, seizure of property liable to confiscation. Section 62, very important, punishment for wrongful seizure. Any police officer or forest officer, if he wrongfully or vexatiously, two things you have to keep in mind, vexatiously or unnecessarily seizes, in that case he shall also be punishable with imprisonment which may extend to 6 months, or fine which may extend to, I think, rupees 500. So moving on to the next. Moving on to the next slide. Section 63, penalty for counterfeiting or defacing marks on trees and timbers and for altering boundary marks. 63 deals with marks on trees. ठीक? And it shall be punishable with imprisonment which may extend to 2 years or fine or both. Section 67, power to try offences summarily. Very important section. The bodies which or the officials which have this power to try the offences summarily are DM and magistrate first class, which has been specially empowered by the state government. Any forest offence punishable with imprisonment for a term not exceeding 6 months or fine not exceeding rupees 500 or both. Section 68, power to compound offences. State government can empower any forest officer who can compound the offences. Now, which kind of offences can be compounded? That has been provided under section 68. Any offense which is not under, which does not falls under section 62 or 63 can be compounded, and it can be compounded by a forest officer of a rank not inferior to that of a ranger and is in receipt of a monthly salary amounting to at least rupees 100. Section 69, presumption that forest produce belongs to the government. So there is this presumption, only one presumption has been made under this section. This act is regarding that forest produce belongs to the government. Chapter 10, cattle trespass. Basically it provides that cattle trespass act shall apply to the provisions of cattle trespass act shall apply on the reserved forest, protected areas and the village forests. Chapter 11, forest officers. See, these section numbers are important. Section 73, forest officers are deemed public servants. Section 74, indemnity must be made for any act which is done in good faith for which a person has been punished. And section 75, forest officers not to trade. So basically they are meant for protecting the forest produce. They should not own any personal profits from the forest produce or the reserve forest for protection of which they are appointed. Chapter 12, subsidiary rules. There are rules which has been framed under this act. So no, wherever a penalty has not been provided for contravention of any rule, it shall be punished with imprisonment for a term which may extend to 1 month or fine which may extend to rupees 500 or both. Last chapter, chapter 13, miscellaneous. Section 79, persons bound to assist forest officers and police officers. So the same duty has been provided under section under CRPC. I would like to know the section number in the comments. Let's see who answers them first. Moving on, I think that is the